and search warrants for a minute. Did you author affidavits in this case?
Yes, ma'am.
And did you use affidavits you authored in support of search warrants to obtain information that you wanted to take a look at?
Yes, ma'am.
And did you author the affidavit that was used for the arrest warrant for Brian Kohberger?
Yes, ma'am.
What did you rely on when you wrote these affidavits?
Be more specific.
Yes, let's focus on the affidavit for the AT&T records. There were 2 search warrants on December 23rd, 2022. Are you with me?
Yes, ma'am.
Okay, so let's talk about those search warrants and the affidavit. First, the affidavit. What did you rely on in the affidavit you wrote for the first AT&T search warrant on December 23rd, 2022?
It was a conglomerate of interviews, data received from cell phones, my observations of some surveillance footage that was taking place, various other things. Go down the line. If you could be more specific on specific parts, I'd be happy to tell you what I'd like.
Okay. In your affidavits, did you rely on cell phone information and cell phone location information?
Yes, ma'am.
Did you work with cell phone records yourself?
No, ma'am.
Did you see cell phone records yourself?
Yes, ma'am, I did.
When was the first time you saw cell phone records that were attributed to Brian Kohberger?
I do not remember what date that was.
Good morning. I'm David Brown, Chief Deputy Hennepin County Attorney, and I'm here to announce today that we've discovered that an Eden Prairie police officer lied about a search warrant and report what we are doing to make sure that several defendants receive justice. Before I get into the specifics of this case, I want to note that because of steps the Hennepin County Attorney's Office took in 2015, this case was brought to our attention promptly, and we were able to take the necessary steps before more harm was done. Under state and federal law, we prosecutors have an obligation to turn over to a defense attorney information that would reveal if an officer's credibility was challenged as a result of misconduct. As a result of that effort, in 2015, we began signing memoranda of understanding with every single police department in Hennepin County, where the departments would inform us of final discipline when that was completed against an officer so we could review those materials. In this particular case, Eden Prairie officer Travis Seraphin obtained a search warrant for a house as part of a drug investigation, and while executing the search warrant, the officers found a large amount of heroin and some fentanyl in the house, and a much smaller amount of drugs in a vehicle. This office charged the defendant with first-degree controlled substance crime and third-degree murder in the death of someone to whom he had sold the heroin. Our prosecutor and paralegal had the search warrant for the house, but didn't see one for the car. They asked for it, and a week later, Detective Seraphin sent a search warrant that was identical to the original, including the judge's signature, except the first page included language for searching any vehicles on the property. In mid-January, the defendant's attorney raised issues about the evidence in this case and demanded a hearing. One of the issues was why there were two search warrants. Our prosecutor asked Detective Seraphin to write a supplemental report explaining that, and he did. At the hearing in late February, Detective Seraphin was required to testify about the two search warrants. On March 16th, the defendant pleaded guilty to first-degree drug sale, and the third-degree murder charge was to be dropped, and they agreed on a lesser sentence after the judge indicated that he intended to suppress the search warrants. However, the judge who heard Detective Seraphin testify was concerned about the testimony. He sent a copy of the transcript and of the two search warrants to the Eden Prairie Police Chief on March 29th. The department immediately began an investigation, and later examination of the detective's computer showed that a week after the search warrant for only the house was signed, a separate document, a new front page, was apparently attached to the copy of the original warrant. Clearly, the original search warrant did not allow the search of the car, and anything taken from the car was illegally obtained. The Eden Prairie Police Department then moved through its disciplinary process and due process. Subsequently, the discipline against Detective Seraphin was sustained, and not long after that, the information supporting a conclusion that the warrant and the testimony were untruthful, as opposed to merely a mistake, was sent to the county attorney's office.
Well, you told me that you're not the guy who understands how to interpret these records. Do you know anything about cell phone towers?
Very little, ma'am.
Okay. So when you wrote this second AT&T warrant, you have possession of Brian Kohberger's call detail records or AT&T records, but you don't know what they mean, so you're relying on somebody else.
Yes, ma'am.
Who all did you rely on?
Mainly it was Special Agent Balance. He was my main point of contact for understanding what was going on.
Okay. In fact, in your affidavit for the second AT&T report, there's a couple of maps in there. Is that right?
Yes, ma'am.
And one of them has some video camera information. That's the first map. Where did that come from?
I do not recall. If you have a copy of it, I can refresh my memory and tell you.
I bet I do. I have what we've marked defendants B.
Are you referring to there's two maps, the WSU focused map you're referring to? It's completely washed out on this copy. I can't even see what it is.
It's hard to see, isn't it? What I want to know is what you relied on to get that first one that talks about WSU and the cameras of WSU. So where'd you get that?
Yes, ma'am. So Special Agent Rob Hilley with the FBI was also co-located with us. He was tasked with analyzing that video from WSU and the surrounding area. So it was a conversation between he and I, pointing out areas of locations where the car was likely seen on surveillance footage. And that's what I relied upon to create that map.
So you created that map how?
Through PowerPoint, I believe, ma'am. Memory serves.
You saved your work on that?
Yes, ma'am.
Let's go to the next map. That one would appear to be a trail or a path from south of Moscow back towards Lewiston or back towards Polk. Is that right?
Yes, ma'am.
Where did you get that map?
Same thing. It was just created using open source satellite imagery, and I think it was PowerPoint.
Did you create that?
Yes, ma'am.
Where did you get the information to draw that trail?
So that was used from the cell phone records referred to me by Special Agent Balance on his interpretation of possible places where someone could have driven between the location that it starts there and then back to Pullman.
Ann Taylor's cell phone expert, Cy Ray, later took the stand, and she asked him about police requesting cell phone records twice in one day for Brian Kohberger back on December 23rd of 2022.
In your experience with working with AT&T records, is it common or uncommon to have two warrants, one that relies on the content of the first and the same day?
It's not uncommon to see a small time period that produces results that would increase the desire, the need for a bigger time period of records. Seeing that entire process happen twice in the same day is extremely rare.
Well, the first AT&T record, we called it today the 48-hour AT&T record of Brian's call detail record. If you were to take that and do an analysis on the call detail record, how long would that take?
Depends on the analysis. So I'll qualify that answer with looking at what was put into the second warrant that shows us at least parts of that analysis to include a route that was identified. To do it reliably and feel comfortable that I'm accurate, at least 3 hours. And that's if you know what you're doing and you have all the tools at your disposal. Arguably, you could spend half a day or more doing that very easily.
So that's interesting. Cy Ray used to be a police officer, and he's saying that analyzing cell records can take up to half a day, not just a couple of hours. And this isn't the trial, of course, but she's laying the groundwork to say that police rushed to judgment and focusing in on Kohberger solely. And remember that FBI cast report, the draft report that Payne said he saw back on December 23rd of 2022? We've heard about it a lot. Cy Ray doesn't believe that that was available back on that date, the day Brian Kohberger's cell phone records were requested.
It's my opinion that Corporal Payne probably is misusing some terms there. I don't see any possibility of the FBI cast team producing a cast draft report on the 23rd.
Thanks for joining us on Creme 2 Plus. I'm Channing Curtis.
And I'm Tim Pham. This is your Creme 2 News Week in Review, where we take a closer look at some of the biggest stories in the inland Northwest this past week. We start with the latest developments out of Moscow.
So we will not be seeing the suspect in court again for more than 5 months now. This after a very short status hearing earlier this morning. We were in the courtroom today. The judge set Brian Kohberger's preliminary hearing for Monday, June 26th. Typically in Idaho, the preliminary hearing has to happen within 2 weeks of the first appearance. The suspect, though, waived his right to a speedy preliminary hearing to give his attorneys time to review the information in the case. The judge reserved the entire week of the 26th for the presentation of evidence, which is what a preliminary hearing is. That evidence is what Moscow PD outlined in the arrest affidavit the courts released last week. After the preliminary hearing will be the arraignment. That's where the suspect will either plead guilty or not guilty. This was the second time we've seen Kohberger in court here in Idaho. He again had a very calm demeanor and again did not address the people in the back of the courtroom, only addressing his attorneys as well as the judge. And the judge did say he will be in custody with no bail until that preliminary hearing. In Moscow, Nicole Hernandez, Creme 2 News.
Because the suspect waived his right to a speedy preliminary hearing, we now know he won't be back in court for 5 months. So what now? I spoke with a trial lawyer this afternoon who says anything is possible between now and June, including the defense and prosecution coming to a resolution. For the public, updates from the Latah County Court over the next 5 months may be scarce. Mo Hamoudi says a lot of the action will be going on behind closed doors.
The prosecutor is likely having investigators investigate in greater detail what occurred in this case, the facts that led up to it. Equally true is that the defense team is doing the same thing.
Moody worked as a criminal defense lawyer for over a decade and is currently a trial lawyer out of Seattle. He says it's unusual to see a preliminary hearing scheduled so far out.
It does jump out at me. It indicates to me that they're negotiating, and it indicates to me that this is a very serious case. Generally, preliminary hearings are not set out that far, but when they are, it's because there are things that is happening in both camps that the public is not privy to.
New at 6, prosecutors building a case against the man accused of killing 4 University of Idaho students have told a judge that one of the officers involved in the case is being investigated by Internal Affairs. Prosecutors filed a notice saying the state became aware of a potential Brady-Giglio material that refers to a constitutional obligation to ensure a fair trial and to disclose material that could impact a finding of guilty. Now, the prosecutor does not say what the information is, or if it involves this case specifically or just an officer who was involved in the case. We did try to get clarification, but because of a gag order, no one involved in the case can answer any of our questions.
New at 6 tonight, KREM 2 is digging deeper into court documents that outline new movement in the murders of 4 University of Idaho students. In our effort to bring you more to every story, KREM 2's Shannon Mowdy spoke with a defense attorney about new filings that reference Brady-Giglio material.
New filings in the Moscow murder case show prosecutors have found and are now sharing with the defense possible Brady-Giglio material. Now, while much of the information is sealed, we do know it has something to do with a, quote, confidential internal affairs investigation of one of the officers in the case.
And it could be huge for the defense, or it could be totally meaningless. So since we don't know what it is.
Defense attorney John Henry Brown says Brady-Giglio means law enforcement and prosecutors have to turn over any evidence or information that may help the defense.
Actually, under Giglio and Brady, prosecutors have an obligation to look for such evidence.
Sometimes that's evidence which exonerates the accused. But with mention of an internal affairs investigation, it sounds like this case is about a potential challenge to the credibility of a police officer.
Most police departments have created what's called the Brady list. And on the Brady list are officers, detectives, internal personnel who have committed some sort of an error in the past. And that the defense should be told about it.
Brown cautions Brady-Giglio disclosures like this are pretty common because not handing over the information can get cases overturned. And the Brady-Giglio material referenced here may have nothing to do with the Moscow murder case itself.
It could be something as small as the DUI 25 years ago. Or it could be something more serious. Obviously, the most serious thing for the prosecution, the state, would be if the officer, detective, or whatever, has some history of not telling the truth.
KREM 2 News reached out to law enforcement in Idaho, Washington, and also in Pennsylvania, where the suspect was arrested, to try to find out which agency is involved. We've also submitted public records requests for more information. Shannon Mowdy, KREM 2 News.
The next court date in this case is a preliminary hearing, and that is set for June 26th.
Joining me now with their insights on all of this are Jennifer Coffendorfer, a former FBI special agent with 28 years in the business of federal law enforcement, and Mark Garagos, trial attorney, criminal defense attorney, co-host of the podcast Beyond a Reasonable Doubt, alongside Adam Carolla. Okay, you two. Jennifer, I'm going to start with you. We've all just been reading these very quickly in the last hour. What stands out to you?
Well, what stands out to me is the Brady-Giglio situation, but I don't think it's anything that really should raise everybody's eyebrows too much. Basically,
so wait, it's a formal term, Brady-Giglio. You understand it. People who have a law background, Garagos understands it. But the general population will wonder, what is Brady-Giglio and what's in the document recommending that?
By the way, my dogs are named Brady and Giglio. I want you to know that.
Okay.
So.
I do not doubt that. I do not. So, Jennifer, with that as just the halt, explain what that is, why there's a Brady and Giglio issue at all in these documents.
So Brady is essentially any information that is exculpatory. So exculpatory could be information that would help the defense's case or hurt the prosecution's case. And again, I'm talking just in layman's terms. That is the best explanation regarding exculpatory. When you're talking about Giglio evidence, you're talking about evidence that is unfavorable or could show lack of credibility on a witness. That all has to be turned over to the defense. So These are the two areas that we're talking about, and this is what's being raised. But remember, it's being raised by the prosecution. They're coming forward and saying, listen, we have an officer that might have these issues, and we want full disclosure here, and that's what you would expect.
Okay, so this is where Garagos, I think you should come in and tell me, I'm going to quote again, what's in that, Brady. And gig or jig? Giglio or Giglio? I've heard it both ways from both of you.
I
Which is it?
I call the dog Giglio, so I'm going to say, and his nickname is Jig, so I'm sticking with it.
Okay. All right, so in that, there is a quote, a confidential internal affairs investigation and an officer involved in the case. And all of a sudden, my head is going to OJ, where the defense seized on policing and attacked policing in any way they could, and it stuck with that jury. What are you seeing when you see that quote?
I had the exact same thing when I was texting with your producer. And she was asking about it. I was going to type, think Mark Furman, because if you've got, and to Jennifer's point, if it was just something that would impeach his credibility, that would generally be Giglio. If it is something that is potentially exculpatory, then that is Brady. And they called this Brady material, which leads me to believe that it's an accusation that this is something that has either been falsified or there's an investigation as to whether he's falsified. You normally see this with other complaints about excessive force and things like that. So I've kind of ruled that out and focused in on the other area that we generally see, which is somebody has said that a officer has filed either a false police report or has testified falsely. There's an internal affairs investigation. That would be Brady material, especially if it was an officer who was an affiant on one of these warrants or an officer who collected some kind of evidence during one of these searches.
So Jennifer, how does this work? We're in the middle of this, right? Nothing has been public. There's no trial. There's very, very little information to go on. How are we already at an internal affairs investigation involving an officer in the case? Who would have spoken up? Who would have pointed him or her out? How are we already there?
Good afternoon, folks. My name is Bill Thompson. I'm the Latah County Prosecutor. And it's sad to be here, but happy to be here at the same time.
I'd like to tell you I'm happy to be here, but why start with an untruth?
Mr. Kohberger, let me preface, there is a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you, through the court process or otherwise, whatever we are allowed to. Just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time, we expect that affidavit will be available to you so you can share the true facts with all of your readers and your watchers and your listeners and all the people who are interested and really need to know what's going on. So please have patience with us on that. We hope to get that to you as soon as we can. As far as Mr. Kohberger, I can share with you that he is a graduate student at Washington State University and has an apartment residence over in Pullman. He has had an initial appearance in front of a judge in Pennsylvania. He is being held without bond, and the warrant from our magistrate judge here also provides for no bond. We understand that he's scheduled to be back in court in Pennsylvania next Tuesday afternoon, and that a public defender has been appointed for him there. The process at this point is, since he was arrested in another state, he has the opportunity to either waive extradition and return voluntarily to the state of Idaho, or if he prefers not to waive extradition, then we will initiate extradition proceedings through our governor's office. If we do that, it can take a while for him to get here. So again, I'm asking for your patience and understand that's just the way the system works. Once he gets here, he'll have an initial appearance with our magistrate. He'll deal with issues such as making sure counsel is competent counsel is represented in case we schedule for further hearings. Your primary source of factual information is going to be the court record, because that's what the Supreme Court says we need to refer you to. So please pay attention to what's going on in court and have people there to watch and hear what's being said. As an attorney, myself and my office, we are limited on what we are allowed by the courts to say outside of the courtroom. So please just work with us. Finally, as the chief indicated, this is not the end of this investigation. In fact, this is a new beginning. We all now know the name of the person who's been charged with these offenses. Please get that information out there. Please ask the public, anyone who knows about this individual, to come forward, call the tip line, report anything you know about him to help the investigators and eventually our office and the court system understand fully everything there is to know about not only the individual, but what happened and why.
I think the state's deadline for discovery has passed. Has the state complied with its discovery obligations, including those outlined in judge's last order and other orders?
We have, Your Honor, and in fact, Ms. Jennings prepared a lengthy summary of all the discovery that was filed with the Latah County Court when our discovery deadline hit. It is lengthy, but there's a lot of discovery.
Sure.
We recognize that.
How much of the, would you say 300 gigabytes?
398 since August 3rd.
How much of that is new information?
Ms. Jennings could speak to that.
Ms. Jennings?
Now I'm ready to talk about the things that same day as the first one. And was there anything else from AT&T that you saw or relied on to get the second one off the ground?
No, ma'am.
And in the first AT&T search warrant, are you aware that part of the request was for timing advance reports?
Yes, ma'am.
And in fact, that also appears in your second search warrant request, right?
Yes, ma'am.
All right. And not only do you ask for the timing advance reports from AT&T, you ask for them from several other companies, correct? Verizon's version of it, T-Mobile's version of this kind of timing advance report, is that right?
Yes, ma'am.
All right. When was the first time you saw AT&T's timing advance report?
I do not recall when I first saw it.
Where is it?
To the best of my knowledge, all of that information from those returns has been provided to the prosecutor's office. Prosecutor's office.
If I tell you I don't have a timing advance report or any from the other phone companies, where do I look for them?
I would direct you back to the prosecutor's office. Everything that Moscow PD received, in that realm, we have turned over to my knowledge.
But you know you've seen this report, is that right?
I do not recall if I've seen the timing advance reports. I'd have to see what it even looked like to know if I'd seen it.
During the course of your investigation and work on the case that became the case that we're here for now, did you communicate with Agent Valance by email?
Yes, ma'am.
And did you communicate with other FBI agents by email?
Yes, ma'am.
And did that relate to the investigation of the scene and later the investigation of Brian Kohberger?
Certainly, yes, ma'am.
Were those communications that assisted you in preparing affidavits and search warrants to carry out your duties in the case?
I do not recall.
But you recall the emails themselves?
I recall sending emails to FBI agents, yes, but
And-
specifics still.
And receiving them?
Yes, ma'am.
Where are those emails now?
All emails that Moscow PD is aware of have been turned over to the prosecutor's office.
What he finds out is that post-murder Raskolnikov and pre-murder Raskolnikov are not the same people at all. They're not even close to the same people. He's entered an entirely different universe. And Dostoevsky does a lovely job of describing that universe of horror and chaos and deception and suffering and terror and all of that. And he doesn't even use the money. He just buries it in an alley as fast as he can and then doesn't want anything to do with it again. And anyways.
Bob Dylan, whose 98 Grammy performance is remembered by millions because a half-naked man with the word soy bomb written on his chest jumped on stage and started dancing like a spaz. But no official video of the incident exists. Did it even happen? 7 years later, the band Eels releases the song Whatever Happened to Soy Bomb, a coded message. Especially because the band's lead singer, the son of Hugh Everett III, who originated the many worlds interpretation of quantum physics. And I'm right back to parallel universes again.
Can we go, why did you pull the CDRs into Castas?
Why did I do that in April? Because I was asked by you to do it for the treasurer.
Okay, is that the only reason you did it?
Yes,
Is that the only time you did it?
yes.
Okay.
That I remember. I mean,
don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it.
Grand jury has indicted the man accused of murdering 4 University of Idaho students. In the last hour, we got the official court documents. Our Brandon T. Jones is in the newsroom right now. Brandon, can you break down what this means for the case?
Nicole, we have the documents right here. It's 3 pages breaking down each charge the grand jury indicted Kohberger on. They indicted him on all 5 of the original charges, 4 counts of first-degree murder and 1 count of felony burglary. This means the grand jury found there was enough evidence in the case for it to go to trial. Now, Kohberger will have his arraignment on Monday at 9 a.m. Also, new at noon, the Latah County Courthouse says we will be able to have cameras in the courtroom Monday morning. That is where he will likely enter his plea of either guilty or not guilty. This grand jury process replaces the preliminary hearing that was scheduled for the end of June. The clerk's office could not tell us when the grand jury officially made the decision. In the newsroom, Brandon T. Jones, KRIM 2 News.